What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. I just got this alert to my email, so I want to share it with you. Some portfolios that are being made available on the market. This one right here, portfolio number one, mixed lenders, and this is going to be mostly credit card debt. I'm pretty sure it's all credit card debt when they say this. Over $7.4 million average accounts 416. Average charge-off date is 2007. Average balance is 17,811. This is going to actually probably be personal loans or auto debt loans more than credit card. They're selling this for pennies on the dollar, $2,500. You might be saying, why the hell would they even do this? Because debt is past the statute of limitations. It's, you can't even collect it. I'm going to show you proof of why they will take the risk on this and they make millions of dollars doing this. The next one is mixed debt portfolio number two, $14.5 million, 602 accounts. Average charge-off date is 2005. Average balance 24,000. These are going to probably be personal loans again. $2,500 is the sale price. And again, I'm going to go over this is past statute of limitations for all 50 states. No debt collector has any business buying this debt, but I'm going to go over and show you proof from the courts or an organization that studies the courts, and I'm going to show you why they are willing to take the risk on this debt, and they make millions of dollars. It's more than the risk. It's almost a, a bet that will pull through for them. Here's a exclusive batch from California. Statute the two $264 million, $264.8 million, 24,512 accounts. Average charge-off date is 2004, which is past the legal statute of limitations for California. California has a 4-year statute of limitations. Average balance is $10,803.93. This is fully the state of California. So why would they even try to collect on this debt? I'm going to show you the reasons why. We're going to pull this document over right now. Now, uh, look at this. Look at this here. I'm going to blow this up a little bit. Now, this is the reasons why they'll do it. Here we go right there. Okay, courts are not designed to respond to the realities of debt claims. Although civil court dockets have changed, the rules they operate on have largely stayed the same. Courts expect both parties to mount a case and present legal arguments so the judge can make a decision based on the facts. So really, defendants rarely have legal representation, and that is not going to change because why would you pay a lawyer uh, $1,000 when you have a debt that's $1,500? If you lose, you pay 1,000 to the lawyer, and you're gonna have to pay the $1,500. Even if you settle, you're gonna have to pay the 1,000 to the lawyer and pay say even half uh, to the debt collector. So it makes no sense. So it's already set up for you to fail unless you know how to respond. So now, uh, if we look at this here, this is just some of the states, but what this represents right here is that consumers without counsel. So you're almost looking at 100%. And in the state of New York, when they looked at this amount of cases from 2008, 2006, 2008, and it was way more than 365. This was just what they studied. Zero, 100% did not have an attorney. Oregon, 100%. Philadelphia, what they had, what 3%. Texas, what 10% of the cases that they studied. In Utah, 1%. Washington, 1%, and they were able. And the reason why they don't have the numbers on all these cases is that uh, all of the states don't report, which I was surprised. All of the states do not maintain and share those reports with everybody. So you can see here. So now let's go down here. This is what I tell people all the time, and we're going to review it real quick. What steps of a debt claim? Now, this is your rights. When I talk about it in my videos, what I'm telling you exactly what your rights are. Regardless if you have an attorney or not, this is your rights. So, plaintiff, creditor, or debt collector files a complaint in court and provides notice of a lawsuit to the defendant, you, the person. Number two, defendant responds with a written answer. You have to respond to the allegations in that summons complaint. If you don't, you're going to be setting yourself up to lose. If the defendant does not respond to court, issues a default judgment for the plaintiff. This is the reason why you have all of this going on right here. This is the reason why, because studies have shown that I think when they did the one that I did my video on yesterday, I believe it was 80%. 80 to 90% of the cases end in default judgment. 80 to 90%. That's why they're changing the rules to say that you can go to nonprofit organizations and and speak to people who are not attorneys to help you with debt collection cases, because they know that this is a huge problem when you have that high number of people who cannot respond because, number one, they don't know. Number two, they can't afford legal counsel. They can't afford to go and pay someone that kind of money to help them. So they end up with a default judgment and the debt collectors win. So that makes this a, they're at the gambling table. And, unless any of this 2,400 and 512 people file bankruptcy and they don't know their rights, they're going to end up having this debt reset because they don't know that it's past legal statute of limitations, and they will get sued and they will have to pay out of their hard-earned money a garnishment. So, number three, the two parties exchange documents including discovery, questions, and requests for information and pleadings, written motions, and other legal maneuvers. So it's not saying that you have to be right on something. It's just what do you believe is your legal, you can make them legally have to prove for you to have a chance of proving that they can't collect on that debt. It's not saying that it has to be something that it's not saying it has to be something that was written in the rules or something. All it is that you're making them state, and I go over it all the time. How did you get if it's a debt collector, show me a signature allowing you to have access to my personal information. Show me the documentation proving how you're coming up with this claim. If you're just buying a claim like this, all you're going to do is get a portfolio. It's going to have the last four digits, and it's going to have the individual's information, and it's not going to even show all of that information. That's all that they're getting, and maybe a few statements. That's not enough to prove that you have to pay the debt. Make them prove everything. Court holds one or more hearings and possibly a trial. If a trial is held, parties can present evidence to the judge or jury. Judge issues a ruling, which either party may appeal. So it's that simple. It's that simple, but people get scared. It's that simple, but people don't have representation. It's that simple, and people just don't know what to do. What I'm telling you to do, and this is me giving myself my own advice, is that you should always respond regardless. You should always fight and make them prove everything. And if you lose, you lose. If you win, you win. That's just the way it goes, but you have a right to do that. And so these are the steps. So I'm going to end the video here. If you have questions and you need help with a court summons, you can, there's a link below this video. You can watch that video that I have, and you have two options. You can either have us, write it up for you. You have a right to have pro se write it up for you, and then you represent yourself. Or you can follow the steps in the video where you can put it together yourself and respond to the summons complaint. At least you'll have a fighting chance. Link to that is below this video. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different. If you, it shows my 8-point validation process, my two-phase settlement process. If you don't have your credit reports and scores, and that would actually show you when that debt was charged off, so you can know when the legal statute of limitations is for a debt collector or for your particular debt. Go and grab the credit reports. Go to your3scores.com. Grab those reports, grab those scores, study them, know them, keep that monitoring service. So if you ever have any questions, something pops up, you know where to get the information, you know what furnisher placed that information on your reports so you can deal with it. If you have debt collectors coming after you, use my 3-pack of letters: statute of limitations letter, debt validation letter, and the cease and desist collection activities letter. Make sure you subscribe to the channel. Make sure you post your questions and comments, and make sure you share and like this video. Thank you for your time.